Peace and love, family. How y'all doing today? Me? Hey, I'm keeping the fight, man, against this beast that we all... Y'all know how that go, man. Keeping the struggle. Like my brother Isaiah say, it's through the struggle that we grow. Y'all see how I'm a little scarred, man. Man, the city did it. It's all the city fault. It's all the city fault, man. And the police made it worse by making me the liable party. Man, I know I'm not liable, man. How can God be liable for something on the earth? That's funny. And then the police department committed all types of fraud. Like I was reading the right to rescission for my state, and it says that, so I'm in the Mississippi Code Investments, Chapter 83, Health Spas. Again, Section 5, Contract with Consumer.
Hold on. Right
to rescind, duration of contract, and particular contracts unenforceable. So the first one, it says a fully completed copy of each contract shall be delivered to the buyer at the time the contract is signed. So that means that the time that you receive the contract, it got to be fully completely. It got to be fully complete. At the time that you finna sign it, it got to be complete at the time you finna sign it. Every contract must constitute the entire agreement between the seller and the buyer, or could be the seller and the buyer, because you operate. You got a debtor and a creditor. You got a debtor and a creditor.
Two sides.
Or the seller and the buyer, that would both be, I guess it could both be the creditor.
That's the three sides.
Yeah. But y'all get what I'm saying. You can operate as a seller and the buyer, because when you sign it, you're buying that, you're purchasing that. When you sign the contract, you're purchasing that instrument, and then you sell it when you give it off, when you dispose of it, when you give it away. You're selling it for consideration. It says that it must be in writing and must be signed by the member. The entire agreement must be in writing and must be signed by the member. Number 2, each contract shall state in at least 10-point boldface type the following. Notice to the buyer. Notice to the buyer. Do not sign this contract until you have read all of it. Also, do not sign this contract if it contains any blank spaces. So what that's saying is, each contract shall state in at least 10-point boldface type the following. So it got to give you this notice on the contract.
Oh yeah.
You got the notice that has to be there. It has to say, notice to the buyer.
Right.
Do not sign this contract until you have read all of it.
Right.
Period. Also, do not sign this contract if it contains any blank spaces. Man, they did not give me none of that when I was in confinement at the police department, because it sure contained blank spaces with that bond box at, because they gave me a pre-trial release form.
Hold on. This is the game they play. Okay? They get your consent or make you think you consented because you signed the paperwork. But what he has hold up on is the truth. He said, They were supposed to give me this and they were supposed to give, They were supposed to give me this and And what people do not understand is that sometimes when they know they are supposed to give you certain documentation, they will to you. You wasn't paying attention the whole time when they was disclosing this to you. So, again, when we addressing the issues, we got to address them in honor, all right? Don't say they didn't tell you, they didn't do this, they didn't do that. What you now need to do is figure out, did you throw any of the paperwork that they gave you away? Did you? Because a lot of times when people go to court, they be so mad they throw the papers away. So you can't say they didn't disclose it to you. They don't have to sit there and treat you like a child if you're supposed to be an adult and read through each one of them documents for you. You are an adult and supposed to know and understand. You don't sign nothing before you read through it. And now he's reading and learning that you also make sure you don't sign nothing with no blank spaces. Also, on the flip end of this, if you do sign something with blank spaces, now you know you have a loophole with which you can manipulate to redress the contract. Doesn't mean that you just get out of it, because you have already assumed some level of responsibility when you sign your name on that document, okay? And so, since you have, now from that point on, it's no need to fight it because there's money involved. Accept the money. Got to learn how to accept things. Accept it. It is what it is. Okay, now, if this is about money, all y'all wanted was, okay, all y'all wanted was money. Well, let me know what I need to do then. Okay, because in those papers that they gave you for your court documents, look in your papers. I want you to just hang tight, stay on live with me, and go rattle through your papers and go get your documents. That if you ever been to court, go get your documents right now. We gonna go through them documents and I'm gonna show you how you have missed the boat. You missed the boat because they gave you them documents. They got it on camera that they gave you the documents because you wasn't paying attention. I know I've been to jail. I've been to court, I've been to jail. They got cameras everywhere. They got it on camera that they gave. This is the reason why they get it on camera. For when you come with your weak ass argument in court about what they didn't do, now you sound stupid because you didn't come properly prepared with the understanding that you got the documents. You just didn't even know what they look like. Now, it's your job at this point to become familiar. Okay? Become familiar. It's with family estate. Become familiar with your financial documents. Become familiar with your understanding of what a form looks like. Become familiar with what the processes are, so when someone submits a bill of exchange to you, you know what that document is. Wow, she getting out of control, ain't she? I mean, louder and louder, and it's ridiculous and ridiculous. What the hell? Mm. Mm-mm. All right, let's see what he talking about right here.
Found myself out on bond, but the bond, the space with the bond, it was blank. Signed that jump, turned it back in. You know, I reserved my rights on it and all that good stuff under threat, duress, and coercion. But I signed it, gave it back to him. Tell me why they took that for themselves, and then what they did was they escorted me out, and then in the main waiting room in the front of the building, they took me to the front of the building where everybody at in the main waiting room. They had another brand new piece of the same paper, not signed by me, sitting on the table waiting for me to pick it up. Like, man, what kind of deceptive fraud stuff is this? Like, what they committed pure fraud.
Yes,
what they did was they had me sign something. They received it basically offline.
Right.
What I'm trying to say is under the table payment. That's what I'm trying to say. Under the table payment, they received that, and then they escorted me out, and then they gave me a brand new piece of paper. And what they tried to be slick, see, they put the paper
he peeped that shit.
on the table where the camera was out the way.
Right.
They know what they doing, bro. They know what they doing. They know what they doing, bro. But like I was saying was, so basically what I'm trying to say is they ain't give me no notice.
Right.
Telling me on the contract, do not sign this contract until you have read all of it. Also, do not sign this contract if it contains any blank spaces. Man, what I should have did was, bro, when I signed it.
No. See, he figuring it out. He trying to figure it out. He piecing it all together, okay. But what he haven't got a full, well, we haven't finished watching the video. He might come to a enlightenment before it's over with, all right. But right now, he seemed like he just contemplating, he juggling it around in his head, with all the knowledge that he forgot. That was really here in the picture. He done figured out they done pull what they call a sleight of hand on him. You know how when people play five card Miley? Well, when they play 5-card Miley, that's what that's called, a sleight of hand. And so they took the one with the bean or the little whatever they juggling around in the cups. They took the bean and they slid it, and they hiding it somewhere. It's not even nowhere in the circle. So no matter which one you pick, you're not gonna pick it because it ain't even under there at all. They can switch them cups around all day long. You not gonna never ever. That's the trick. You can say they committing fraud, but if this young man is not able to direct his request, okay, what he got to do is submit. I mean, what you can do. I'm not giving legal advice. This is only legal advocacy. Okay, based on my degree of knowledge and understanding of the law, I do feel that I am competent enough and have won and been successful to an extent in my case to have the degree of knowledge to be able to relay some degree of legal with some degree of legal competency. And so now that I've got that disclaimer out of the way, I want to see this. Okay, the reason that I would suggest in this type of situation, I would First, look at all the documents they gave you when you went to jail. Um, you know, I gathered up all the doc when they put me in jail. Okay, they got mad at me the second time they put me in jail because they noticed that the first time that I took the ticket out the bag and kept it for evidence. When they took my closed property, I took the property tag, the card off of they. Man, I'm telling you, come with it, you understand? They hate my guts for it. I don't know why. But I took the property tag off the bag. Okay, when you go to jail, they have, oh, Shorty, when you go to jail, they have a, a, a little bag that they put your property in, and they have, and in the property thing, um, shut. Let's just stop it. All right, let's get it. We live, baby. We all the way live.
I should have held it up to the camera in the yeah. That's what I should have did. But anyway, number 3, every purchaser. All right, so number 2, they gotta have that boldface type, and they had to have that note.
Okay. He going on, he's saying number one and number two, but he didn't say, oh Lord. Now I done left from outside to get on my broadcast if she wanna discuss this matter with us. But she's scary too. But I want her to build her confidence. The hold on one sec.
not sign this until you have read all of it. And don't sign this if it contains any blank spaces. That has to be contract. Number 3, every purchaser of a membership shall be entitled to cancel his or her contract within 5 days by notifying the health spa in writing by midnight of the 5th business day following the date of purchase of the membership contract. So what that's saying is 15 USC 1635. A lot of people familiar with that. That's the federal right to rescind code. But in my state code, it says that we have 5 business days to cancel the contract by notifying the health spa in writing by midnight of the 5th business day following the date of purchase of the membership contract. So if you really understand what that's saying, it's saying that we can go past 5 days, bro.
Right.
People not even, like, even in the federal law, you can go past, because it's 3 days in the federal law. You can go past 3 days, bro.
Right.
I'm trying to tell y'all, bro. What they saying is, for example, this one, it says, by midnight of the 5th business day following the date of purchase of the membership contract. Y'all be forgetting they consumers too. So that mean, like, if I turn this piece of paper in, if I turn that in,
that there was a purchaser.
They just purchased it. Now they got 5 days to do what they got to do to cancel it. The liability not on you. We got to stop thinking the liability is on us, bro. That's the biggest problem. We be thinking we liable for something. We're not obligated to do nothing. Period. Period, bro. Especially if you know who you is. If you know that you a God, why y'all think the Constitution says that they can't hinder freedom of religion? Because that junk true, bro. We all gods. And until we start acting like it,
right,
you won't see it. You got to know it, first of all. But anyway, like I'm saying, it says written notification is deemed given if mailed or delivered by midnight of the 5th business day. All money collected pursuant to the contract shall be refunded to the purchaser, exercising the right to cancel. So the one that's exercising the right to cancel shall get the money, not the purchaser as the corporation, the one exercising the right to cancel. Not the one canceling it, the one exercising it. Number 4, each contract shall contain the following notice in at least 10-point boldface type. If within 5 business days you decide you do not wish to remain a member of this health spa, you may cancel this contract.
I'm going to tell you why they don't have a right to cancel. All right. The only reason they don't have a right to cancel is because here's how it works. Okay. Once you have decided that you have interest in the deal, if they made the offer to begin with, you signed, accepted the offer, even if you did it not knowing that they was purchasing something from you, that can. That's why the law said it can be voided. It can be considered as void. It can be voidable. Now, just because something can be void or can be voidable, that's not the only side to the coin. Please understand what happens when you cancel uh, your side of the agreement um, once the agreement has been solidified. Please understand. See, one thing about it is he's getting an understanding, contract law, but in part because these rules are effective once the contract is. But here's the loophole, here's the catch. Like he said, you got more than 5 days to decide what you want to do. Guess why? Because the contract is only solidified when you uh, determine that it is. Just like when you determine that you are the debtor and make payments on the contract. And that's what your comprehension of what type of agreement you just signed or agreed to. You thought in your own mind that you was supposed to have been sending payments, and they uh, additional payments, and they accepted them as donations. They don't have no obligation to turn down no donation. You sent the donation. They sent you a bill. They sent you a bill with your check on it. All right. Even when you go to jail, they sent you some type of presentment. I looked at my sister paperwork when she got out of jail because they didn't do the same thing for me that they did for y'all. Because asserted my rights from the giddy up. Matter of fact, I did a citizen arrest on one of the police officer that was arresting me. I read her Miranda, her and him. It was two officers, but Drew and changed standing. He was the actual one making the complaint, and then he passed it off to her to actually do the report. So I definitely got a, a genuine issue before the court on that, with them pulling that switcheroo. Because how can she testify to secondhand knowledge in the before the court? That's fraud on the court right there. Because she don't have no clue of even what the incident was about. How can she write a report on it? Okay, moving right along. I am sharing this with y'all because y'all need to understand that. You need to be able to understand what you looking at when you looking at these documents. If you looking at your court papers, you need to know what you looking at. Okay. Um, that's why I had the broadcast where people can come in and you can have your document right there. We had a split screen. When you see us casting like that with the split screen, come on in, all right? And get you some help, get your help you need. Just come on in and make sure that you be prepared. Don't be shuffling papers all in the mic. Come on in before the court and understand that you is before the court. Because this is the court, the people's court. This is the people's Commonwealth Estate Court. Don't come on the broadcast being immature and saying stupid stuff. What I mean by saying stupid stuff like, oh, what is this about? Well, don't jump your ass on until you know what it's about. Bring your documents and your paper like you coming before court, and you can have your complaint ready. And what we will do is we will walk you through um, in a administrative capacity to help you understand your documents that you submit before the people, to say, okay, I was given this particular document and in it in under duress. You need to be aware that you entered into a contract under duress. And if you are not aware of that, the court will inform you of your position and what rights you have in the capacity that you have contracted on. Because it is important and imperative and extremely essential that you understand which laws are at stake when you enter into contract or when you have or have not entered into contract. For example, people think that you have a standing contract with the state when you have not submitted all of these documents to say you uh, want to be granted independence from the state, okay? And people not even understanding that that's what those documents are for. You know, they just paper, copycatting papers, not having a understanding, not duplicating the understanding, all right, of what the papers and what the documents is for, all right. Now, what we're going to do, moving right along, okay? Moving right along, we're going to go over here and we're going to just keep discussing this until we get an understanding. Got to get an understanding. Even in the Bible, it say, in all I get and get understanding. If you don't get understanding, what happens is then, oh, here we go. That's it say, in all I get and get an understanding. Because if you don't get an what you wind up doing is running off up in court and going and getting smashed in court because and you thought you because you was bringing up a UCC that you really had trumped something, not understanding you was in the wrong court to even bring up the UCC. See what I'm saying? Y'all don't even understand that UCC don't even is not even applicable in the lower courts. What are you doing? Those are federal uh torts. Even the Bill of Exchange tell you that this is a civil claim. This is a this is civil law and rules and regulations in the Bill of Exchange. That's the common law Bill of Exchange sort of. Uh, that's our rules, okay? Now, that's why you're supposed to find out what the rules of each court is when you go into that court so you can know which ones that they violated of their own rules. Don't come bringing in rules from federal court, talking about rules in federal court and went way up to the Constitution when you could have dealt with this down here, standing. standing is applicable in all courts. I don't care if you go to a court in another motherfucking country. I guarantee you, standing and jurisdiction is an applicable concept in all courts. Okay? In all courts. You got to have grounds. You got to have a reason to be there. To call people attention to a matter. That's what court is for. Is call attention to a matter. Amongst the people, amongst the community. You need to call a matter to the attention of the community. This is the reason why you need juries and so forth. That's the community. All right? The community of people to judge the matter. So if you bring your matter here in Eagle Legacy State Court, we will give you a court review. We will help you review the matter and give you an administrative commentary on it. Okay? And what I mean by administrative commentary is a person, in order for them to administer or minister to you, they would need to display some level or degree of knowledge in that ministry. And so since we are in the ministry of law and we endeavor to consistently build on our knowledge of the ministry of law, just like any other court, which you may not be aware of this, but in any other court, the reason that they need you to put on your case which laws and statutes are applicable is because they don't know. They don't know. And it's foolish of you to go in there assuming that they do. You're supposed to assume the opposite, that they do not know. You're supposed to assume, oh, you didn't know any better. Oh, you ain't know I was sovereign. Let me put a record before the court so that y'all be aware that put that on the record. Y'all didn't probably get the memo. Let me make sure y'all got served proper notice that I'm sovereign and I'm not, I don't fall under your jurisdiction. I adhere to common laws. And so, since I don't adhere to color law, I need to know what kind of jurisdiction is you holding me up under. All right. What kind of jurisdiction is you calling me up on so that I can properly build a defense or response? That's standing. You don't get past that. You don't need to argue no facts or nothing like that. What your name was spelled and all that bullshit. Okay? And I only say it's bullshit because in a court of law, that's not what you argue. Names. They didn't bring your name before the court. Okay? You only assumed that they brought your name before the court. That's where you had fucked up at. And see, we don't fall under their jurisdiction. We can talk how we want to in this court of law. Because we keep it real over here. That's our court rules. That we keep it real. Okay? And that we be a person of integrity, not to share anything with you that we think is contradictory to the elements of the law, natural law, which is to be fair in our dealings and to be persons of integrity and honor. That if we present something to you, uh, as far as advisory type of uh, 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 content, that we be responsible with that content, to give you instructions, to advise you. Not, we don't, everybody when they give their disclaimers, they'll say, um, this is not legal advice. Um, we advise, a lot of people will say we advise you to seek competent legal counsel or whatever like that, okay? But a lot of them don't, which they should add that word competent. Because to me, it's irresponsible to tell somebody, go get a lawyer, a licensed attorney. I think that's very irresponsible, if you ask me. And I would like to petition the court about that. Because them type of disclaimers, to me, is very irresponsible. That's still almost as responsible as allowing the person to think what you said was legal advice. You gave them legal advice. That's, in the streets, we call that constructive delivery. Okay? Since y'all didn't know. We call that constructive delivery in the streets. Whenever you go and you tell somebody else how to go get some Gina, or tell somebody else how to go scope some dope, okay, and like what they call a pimp, okay, they can get him on constructive delivery of some Gucci, because to go in between for the fuckery, okay, to occur, for the crime to, he is the go-between, the broker for it. He the broker. He the broker. He hooking the John up with the prostitute. All right. So in the same regard, when people tell people you need to get a lawyer, go get a lawyer, and not be very clear as to what type of lawyer they need to be getting and what qualifies that lawyer as a more equitable option. Like when I tell people, baby, just get you a lawyer or just shut the fuck up or whatever like that, that's their best interest. Any lawyer that don't tell them to shut the fuck up is incompetent. Okay? They incompetent off the rip. If you look at any of these big cases and real cases, and when I say real cases, these people, a lot of them, we just dealing with little misdemeanor case. But I'm talking about people on trial for murder and some big federal cases and this and that and this and that. You don't hear them say a motherfucking thing on the record. It's a reason for that. If you're not the name, why are you speaking? Shut the fuck up. How about that? Why are you speaking on the record for the name if you're not the name? It's contradictory. Them two don't go together. Them two don't go together at all. If you're not the name, why is you all on the record on behalf when the court docket is calling the name? Huh? We need to be, we need to be clear on what's going on here. what's really going on in the picture. Okay? We need to be clear what's really going on in the picture. Okay? Because if we not clear on what's really going on in the picture, we tend to make an ass out of ourselves. I know when I first was learning all of these things, um, that I would have to most likely go to court. So I started learning a lot about court, and that's why I know a lot about court, not a lot about the paperwork on, I'll say, the tax paperwork stuff. I'm in the process of learning it. But even in learning about those documents, you'll find that I'll be teaching while learning, because I noticed that a lot of people um, that are teaching about these documents only know them from one perspective. Once I found out what the document was for, that's all I need you to tell me, because its implications I can um, calculate its implications myself. In other words, what I can do with that type of document is determined by the type of document it is. This is why we need to learn in depth the understanding of the bill of exchange. That's another thing. I took a lot of time learning the bill of exchange. What is it? I downloaded it, a copy of the bill of exchange. I printed it out. I gave a copy to my daughter. I told her, I say, this sucker thick. You read this and I'm gonna read this part. Let's split this shit up and divide and conquer out this around this motherfucker. We go divide and conquer around him. And when what we was finding that once I learned something, and then we talk and have our meeting of the minds, and I say, well, what did you learn about it? And she might say, well, this what I learned about it. And I say, well, this what I learned about it. And we exchange. We make an exchange of knowledge of what we gathered up. And then she said, well, I really didn't get an understanding of it. I said, go back in. I'm going back in too. And that's how we do. We exchange the knowledge. And I tell her, when I teach her something, I say, tell me what you got out of what I said. See, I can't assume that she got the understanding that I was relaying unless she summarized and give it back to me. That's how you do in court, when you have your briefing, and then when you have the body with all your arguments in there, and it's like an oral argument, all right, and then you got your summary, which is like the closing arguments, all right. And closing arguments are meant to seal the deal. All the understanding that needed to be relayed and considered is on the table, and it's to make sure that that understanding has been relayed, all right, and not forgotten in the mass of the body of all the arguments and this and that. And this, the points need to be made in the closing, the main points. All right. And so once you make those main points, boom, that seals the deal. That's like buying a house. It's a closing on the house. All right. And that's a deed conveyance. Okay, that's the conveyance of a deed. That means something happened here. All right. Something of value exchanged here. All right. And you dock that. Document that. That's what a docket is. They document all the exchanges of value. What was value, what was not. That's what striking stuff from the record means.